May April. We have filed one criminal appeal, which is pending before the Honorable Court, allowing that there is an application for suspension of sentence. On the last occasion, the matter was listed on 29/5. 2 weeks was granted to the PP to file objection. They have filed objection. So let it come up next week, any date, man, for orders.
Next week, any day.
26. Like.
Item number 17, my lord. In this case, I'm praying on behalf of Mr. D. Das, Lordship. Is some personal difficulty today, Lordship.
Item 17.
Yes, Lordship. Matter was placed before the mediation, Lordship, and almost settled, Lordship. You can be disposed of tomorrow.
Mediation matter is settled, my lord.
So
Okay,
tomorrow, you
tomorrow.
can be disposed of, my lord.
Tomorrow.
Yes,
Tomorrow.
Item 17, list the matter tomorrow.
Yes, Lord.
Marshal.
Why not today?
Lordship, Mr. D. Das is absent, my lord.
If it is settled, what is the
Lordship,
requirement?
I'm not in the case, Lordship. Let it be in his presence, my lord.
Okay, he wants his name there.
Yes, Lordship.
Yeah, so.
May I please, your Lordship. Lordship, I beg to mention item number 9, Lordship. Item number, today matter has come up for orders, Lordship, and today I have some personal difficulty, Lordship.
What is the difficulty?
Difficulty, Lordship, there is a Lordship, 13 witnesses.
Huh?
13 witnesses in this case, Lordship, and we,
So this is, we will take up the 389 only.
Lordship,
We don't have to take up the entire, the main matter. Only the 389 application we can take up.
Lordship, because there is a 13 witnesses, Lordship, and we have only 3 witnesses, copies of evidences, only 3, Lordship. So I may be allow some time, Lordship, to collect the other evidences, Lordship. We could not,
Has the paper book been made?
No, Lordship.
Okay, item 9, no?
9.
Mr.
Ayu Chaudhary, Lordship.
Ayush Chaudhary, Learned Counsel for the petitioner, prays for time on the ground that he does not have all the copies of the evidence adduced in the trial. Prayers aloud. List the matter. After
After a week, Lordship.
a week. Full stop. As the LCR has arrived, registry to prepare the paper book in the meantime.
Lordship, deeply obliged.
Yes.
I may pray for a listing of a matter for orders, my lord, for consideration of the IA for suspension, my lord, on Friday, my lord, if possible.
My lord, item number 15, it is fixed for hearing today, my lord. In fact, my lord, yesterday we were informed that, my lord, they will be filing an objection today. And therefore, my lord, I could not prepare the my compilation and everything, my lord. My lord, today morning again, I am informed that they are ready for the hearing. If that be so, my lord, the urgency is mine, my lord. Let it be on next Tuesday with a rider that no objection will be given. I'll argue it on next Tuesday, my lord. Because yesterday, my lord, at 8:30, we were informed that they will be filing an objection. They want to argue, my lord, very well, my lord. I'm not against that, my lord. So, my lord, it may be fixed on next Tuesday, my lord. We'll finish it off, my lord.
NDPS matter.
NDPS matter for 7 years.
389 application is.
389, my lord, there is an observation by this court, my lord, on 389. Your lordship may see the IA. Your lordship has observed that hearing of the IA would amount to hearing of the entire matter, and therefore the entire matter would be heard once and for all. That is the observation by your lordship in this IA.
So paper book is also not prepared.
Yes, it is prepared, my lord. I have got a copy of the
I have
paper.
not submitted a copy.
Give me item 15. Ganja.
Yes, ganja. Ganja will be decriminalized.
Huh?
Ganja should be decriminalized. These are used in some pujas also, these are normally used. My lord,
Paper book is here.
yes, I got the paper book.
But Lordship, copy has not been served on you.
Are
Probably,
you sure?
yes, Lord. It means served on the state government, Lordship, because earlier state of Assam was made party.
Paper book has been furnished upon the Learned Counsel Narcotics Control Bureau, Guwahati. Why don't SCKL for received by so and so for Mr. SCKL. Look at this.
I think inquiry, Lordship.
Huh? Please look at this. Who is this person? B. Sahu or something like that. I don't know.
So, my clerk is. Now you make it. I'll make inquiry. Also fixed for hearing.
Let it be on next Tuesday for hearing, my lord. Because the urgency is mine. After all, I mentioned it, my lord, because for 7 years, my client is behind the bar.
Behind the bar.
Behind the bar for 7 long years. Hardly any time left.
How many kgs? 110.
110 cases.
110 kgs, correct? Right.
Well,
Uh,
conviction.
On the prayer made by Mr.
It may be
M.
both sides, my
Biswas,
lord, because my lord,
Huh?
in fact, we were informed yesterday that they will be filing objection.
You are asking for a gentleman.
Fine.
Otherwise, you want to hear, I'm ready. We are ready. Heard Mr. M. Biswas, then counsel for the appellant. Appellant. Who submits that the matter may be listed in the next hearing. As the paper book has been received by him. Good, sir. Office note dated office note dated 26/7/23 indicates that paper book has been furnished to one Mr. B. Sahu for Mr. SCKL standing consultancy. Accordingly, on the prayer of the for the party for the applicant, this is the matter in the next week.
24th, my lord.
24.
Please, your lordship. I like to mention under filing number 8624 in criminal appeal number 229/2023 for listing matter.
New case or old new case?
I am madam.
When?
One Monday night.
Okay.
Permission, I think one.
May I please, your lordship? Your lordship, the appellant is convicted under section 6 of POCSO for
Right,
regard
Michelle Davy, learned counsel for the legal aid counsel.
legal aid
Appearing
counsel.
for the appellant. Who submits that the. Where is the judgment and order? The judgment and order dated
3/5/2024.
3/5/22. 24.
24.
24. And the sentence order dated 9/5.
9/5.
Passed by the special judge Bongaigaon. In special bracket P, case number 85 bracket BGN of 2022. Should be set aside. No, before that, comma, by which the appellant has been convicted under section 6 of the POCSO Act. Comma should be set aside. Admit the appeal, call for the LCR. Mrs. Yes. A. Begum. Additional PP appears for the state. Then you have got to give for the
Yes.
victim
Not
or the guardian of the victim.
yes, to the respondent to lordship.
So point number 2.
Yes, informant.
This there,
Informant lordship.
informant. Who is the informant?
The father lordship.
Father. Where is the petition?
Page number.
Huh?
2 lordship.
Page number 2.
This one.
Okay. Appellant to take steps for service of notice upon the respondent number 2. By submitting a copy of the appeal petition to the
To the
PP.
lordship.
To the PP, who shall thereafter communicate the same to the OC of the concerned police station. For issuing notice to the respondent. This is the matter after 4 weeks.
4 weeks. 4 weeks.
Issue notice returnable in 4 weeks. Huh?
Okay.
I think you.
Yes, because I am also a legal aid counsel.
Yes, sir.
Dear Raj,
They the legal aid counsel of
section 354B as well as section 4 of the POCSO Act.
submit the judgment and order dated
11/7/2020,
11/7/2024.
2024.
By which the appellant has been convicted under section 354B IPC read with section 4 of the POCSO Act. To be set aside. Issue notice returnable in 4 weeks. Before that, right, the appeal, call for the LPR. Then issue notice returnable in 4 weeks. Acha, wait, huh? By the special judge, huh? Issued back by the special judge in special POXO bracket, case number 37 of 2020. Okay. Then Miss A. Begum, additional quickly accept notice on behalf of the state. Then for the point number 2, the same thing.
Obliged.
Item 3.
May I please? But this is an appeal, my lord, but Lordship kindly see there is some issue involved in this appeal, my lord, and I am in the custody. Well, what happened, my lord, this appellant, initially they were acquitted by the Sessions Court, my lord. Long before, my lord, in 2013. Then the state has preferred an appeal against acquittal before this division bench. The informant, basically. At the time. So after during the hearing of the appeal, the opinion of this honorable court, the division bench, is that there cannot be any, there is no material as such, and court has failed to opine anything, my lord, to take a view in this case, my lord. So there is a direction to the trial court again to take fresh evidence to come to a conclusion so that the one view can be taken into account. Because otherwise, court is in the opinion that after the going by the evidence on record, there cannot be even the two possible voids or even not even a view at all. So there is a direction to the Sessions Court, remanding with the setting aside the judgment and order, and remanding with the trial for the fresh evidence. Now, the trial court this time, the prosecution has, now they have declined to adduce any evidence or examine any of the witnesses again. So there is no evidence at all. Without recording, without defying the High Court division bench order, now on the basis of the previous materials, whatever the earlier, again, I have been convicted this time.
Earlier you were acquitted.
Earlier I was acquitted on the same evidence. And there is a direction from the High Court to take the fresh evidence final.
So no fresh evidence.
No fresh evidence. Only the High Court has said that we can't take any opine, my lord. We can't opine on the basis of the evidence. We can't take a view. And the learned session judge, he has taken a view on the earlier evidence, my lord. This is the case, my lord. And I am in the custody, my lord, the 8 years old, and to see the agony, my lord, and to see the
When was the earlier judgment and order?
the first judgment, lordship will find at page, my lord, 147. Page 147, annexure 4, my lord.
47?
147, my lord, in the IA. This is the judgment, my lord, where we have been acquitted, my lord. The Sessions case 207. And the recording, the dates of recording evidence is the last date is 2013. 24/5/2013. And the date of judgment, my lord, 28/9/2015.
Where is the High Court judgment?
Now, Lord Lordship, kindly see to the High Court judgment, my lord, page 166. And the paragraph more appropriate, my lord, the 170, my lord, page 170, paragraph 12 and 13. Paragraph 12 and 13, my lord. Last 4 line, my lord, is important. Paragraph 13 is the direction, my lord.
Then the judgment has come.
Yes, my lord, then the judgment has come, my lord. 173 it starts, my lord. This is the judgment, my lord. And lordship kindly see the paragraph 7. And the date of recording of evidence, my lord, same date, it is in 2013 itself. Page 174. The chart they have prepared, my lord, date of commencement of the evidence. That was the last date is 24/5/2013. Same days as before. And the judgment and the paragraph 7 is very important, my lord. In the judgment, the learned PP has declined to produce further evidence and is submitted before this court. The burden lies upon the accused. Absolutely, my lord. Absurd, my lord.
Correct. Heard Mr. A. Bora, learned senior counsel for the appellant who submits that the impugned judgment and order.
Lordship, we have not filed our objection, Lord.
I'm not doing anything. I'm just admitting.
Probably they want to file an objection why the division has not probably directed for it taking the fresh evidence. What kind of objection, my lord, in this case, my lord? What kind of objection they want to file it? I couldn't understand, my lord. They want to say that the division bench was wrong in sending back the trial, or they want to find an objection that the trial court is right. What kind of objection, my lord, in this case, my
No,
lord?
no, let.
Please, maybe a treasurer, there is a direction that's not been followed by the trial court, by the high court.
No, you see, right now, basically you want 389, I think. That
Yes,
is
sir,
what it is.
389.
That's what.
IA is there, Lordship.
Huh?
IA is there, so.
IA.
The 80 years old, my lord, because of the, he is
No,
in the,
no, you see, this has come up for the first time.
that's true, my lord.
Only because of that. Otherwise, you've got a case. No doubt about that. Only thing is that some kind of procedure has to be followed. So we can fix it for the after tomorrow also. Your plain instruction,
Yes, my lord.
because the simple fact of the matter out here is that there's no additional evidence taken.
LCM should be
No,
there.
no, madam, when the records, that, you see, what you do, I'm giving you time only because of one aspect. You go through the judgment and just see only one aspect, whether any additional evidence was taken or not.
Lordship.
If additional evidence was taken, then okay, then we will see. But if no additional evidence is taken, then how can you take two differing views on the basis of the same evidence?
Lordship.
When the high court has failed to take a view, my lord, the session judge of his own, my lord, without taking evidence.
Anyway, it appears that this has to be set aside. It appears so.
Lordship,
Actually, there's,
one
see,
should be
because
given,
I don't think that is
Why
the only
one?
thing that has to be seen.
The person is 80 years, is behind the
No,
bar, my lord.
For IA Lordship,
Lord-
1 week time
Why
for
1
IA
week,
Lordship to file objection, Lordship.
No, you see, madam, it's very simple. It's very simple. The division bench of this court has held that fresh evidence should be taken,
That is their Lordship.
and
that
they
is
were
their
acquitted earlier.
Lordship, that is.
They were acquitted.
Then Lordship, on the
Arre,
retrial.
if they were acquitted, why are they not taken out from the jail?
No, my lord. This time they have convicted, no?
They were convicted.
Now this
Okay,
time
now
they have
they've
convicted.
been, now they've won.
Now they have convicted.
Now they are convicted on the 302 Lordship. Then in the second.
No, yes, but then it has to be on some basis.
So Lordship, IA is there. So for the IA, I need.
So you want to say that the
No,
division
you see, madam,
No,
only,
I don't want to say.
no,
anything,
no,
Lordship.
madam,
My
only thing is
learned
that
friend
not,
may say something, but
let us
not
not
to
go into the merits of the case. As to the only, you see, merits of the case will be gone into only when some additional evidence is taken. If no additional evidence is taken, then there is no ground
But
to have a
unless the
conviction.
LCR is there, Lordship, I'll have to file the objection, Lordship. 303,
No.
IA is there. So once I'll have.
I have given all the papers, my lord,
I'll
here.
have to go through the IA.
All the paper
LCR,
book, everything I have annexed here, my
No,
lord.
no, you see, the thing is that this,
Just to delay, my lord.
because
This is
when the
absurd.
court, when you come to page 176, come to 176. This is the judgment of the trial court. Just read page 77, page, para 77. Yeah. The learned PP had declined to produce further evidence. What more do you want? Are you saying that the learned trial court has made a false statement?
No, Lord.
Can you say
They
that?
have not made a false statement, but as the learned session judge have given a conviction under 302 on the basis of the earlier evidence.
Earlier evidence, there was no conviction, there was only acquittal.
Acquittal, but now in the second judgment, on that ground, they have.
There is a conviction
Conviction,
on the basis of the same evidence.
same evidence.
Can that be allowed?
And the High Court has opined, my lord. Kindly go to the judgment of the High Court. What High Court said, my lord.
Anyway, day after tomorrow.
Day after
Right.
tomorrow. All
Just
right.
a minute. Third, Mr. A. Bora, learned counsel for the.
But in Monday, Lordship, because Lordship, Monday, Lordship, because I'll have to go to, I have to place my objection in the procedural way, Lordship. Let it be on Monday. Tomorrow is Thursday, Lordship, because I'll have to file it again.
But
Then it will-
this
Only
person
2
is,
days.
this person is in jail.
Only
One
2
day
days,
is a,
Lordship, because
one day is a very long period.
And he's 80 years, my lord.
80 years old.
80 years old man.
Lordship, because I'll have to file it, Lordship. Today I'll have to go, I'll have to write, then tomorrow I'll file, then also it will not. So Monday.
No, you file tomorrow. What is there? We'll take it up on, thing. We'll take it up on Friday.
Come, Lordship, because
Yeah, we'll call for it. This court will call for it. No. You see, out here, it's apparently very clear that the order is not correct. The impugned judgment is not correct. It's only because of that.
For sake of objection,
If there was some cases that I could understand, but there's no case.
Yes, my lord. It's just an
Heard
objection
Mr.
for the sake
A.
of
Bora,
objection.
learned senior counsel for the appellant, who submits that the impugned judgment and order dated 5/6/2024 passed by the Sessions Judge Barpita in Sections Case number 207 of 2011 under sections 147/302 IPC should be set aside. In as much as the appellant could not have been convicted without adducing further evidence in terms of the judgment and order dated 24/7/2019 passed by this court in criminal appeal number 17 of 2000. Next part. The case of the appellant is that the appellant had been convicted and had been acquitted of the charge under
302 by 147.
section 302/147 IPC by the learned trial court in Sessions Case number 207/2011 by judgment and award by judgment dated 28/9/2015. Being aggrieved, an appeal was preferred against the impugned judgment dated 28/9/2015. Before this, the appeal was registered as criminal appeal 17 of 2016. Next para, criminal appeal 17 of 2016 was disposed of by judgment and order dated 24/7/2019 by holding, by directing the learned trial court to take further evidence Procedural. Subsequent to the impugned, no, subsequent to the judgment dated 5/6/2000. No. Subsequent to 57. Subsequent to the judgment and order dated 24/7/19, passed in criminal appeal 17 of 2016. The case was remanded back to the learned trial court. And the learned trial court in para 7 has recorded has observed as follows. Page 176, para 176, para 7, okay. Next para. The case of the appellant is that when no further evidence has been recorded by the learned trial court, the appellant could not have been convicted in the subsequent judgment and order dated 28/9/2015, passed by the learned trial. Admit the appeal, call for the FCR. Issue
Monday,
notice.
Lordship, 17 witnesses are there, Lordship.
Okay, Monday.
Monday, Lordship.
Accordingly, issue notice returnable, no, just issue notice, Miss A. Begum, additional PP, except notice on behalf of the state government. List the matter on Monday.
Lordship.
Then in the IA, you write it.
3rd minute, 24th, I am will not. Well, only, let it be on Friday itself, my lord.
No, Lordship, 17 witnesses.
No, what is
I'll
it?
have to
This is
not-
an, just absolutely, my lord,
That
this
is
is an
not.
objection for the sake of objection only.
No, Lordship, it is not. that
Why,
they
why?
added friends.
We expect the public prosecutor also should be fair
No,
enough.
No, you see, one thing, madam.
Why
one-
she's
no,
objecting
just a,
to
just,
Because
no, just a minute, madam, one thing he's correct, you see. When there is no additional evidence, how can the trial court have changed its decision from acquittal to conviction?
For that, Lordship, I'll have to go to the LCR actually, Lordship, in the procedure.
No,
Lordship.
madam,
But now,
madam, this is the observation made by the trial court itself in the impugned judgment. Now, you see, what is the sanctity of an observation made in the judgment? What is the sanctity? There is a judgment of the Supreme Court, I believe, with regard to
that is
civil
there,
matters.
Lordship. There's
Then,
my humble prayer, Lordship, Monday, Lordship, because 17 witnesses.
Monday, I'm not, Monday, Tuesday.
Because, Lordship,
That's the problem, my lord.
other, we are engaged only 3 PPs, Lordship, all have, we'll have to go through in like
What
a
a-
proper way,
that-
Lordship.
Just the
So
one
that-
point, my lord.
Lordship, it is not
This is
like
just
that,
an, my lord,
not like
I'm very
that.
sorry. Sorry to say, my lord, this is the
No, it
behavior
is
of the
the way,
public
Lordship.
prosecutor.
Everybody needs a.
My lord, I can understand. It's only simple point. A High Court APP can't understand a single point here.
One day,
So
Lordship,
what kind
we'll
of
have to
affairs we are having? Very sorry state of affairs, my lord. I must say, my lord, very sorry, my lord. When the judgment is clearing, defying the High Court order,
Humble prayer,
and
Lordship.
she's wanted to justify it, my lord.
no, right. Then in the IA, you're right. In the IA, right? Mr. A. Bora, the senior counsel for the applicant, who submits that the impugned sentence should be suspended and the petitioner should be released on bail. So then you put out the facts again, for that. This is the matter on. When will you be here? 23rd, 24th, 25th?
I'll be on 25th, my lord.
She's praying for 25th. Probably you'll get it. So what will do?
It's a prayer, Lordship, humble prayer, Lordship, because
our prayer is more important than the person
No,
with
Lordship.
80 years is old, my lord.
That, Lordship.
Where is the
For one
apparent on the face of the
thing,
record, my lord?
for one
The
thing,
heart prayer is
Lordship.
more important.
Not that war prayer is important, Lordship. We'll have
Then
to
what
find
is the
procedure.
importance, my lord, here?
Procedure.
What is the importance here, my lord?
Council will always say in this way, Lordship.
No, I'm not
Yes,
saying
yes.
always not saying.
It is not
This
like
is
that,
apparent on the
Lordship.
face of the
No,
record.
You see, it's not that.
What is this? He's dominating. He's.
No, madam, it's not that. It's not that whenever senior.
We are so all advocates.
Madam.
He's saying as.
Yes,
if
I'll say, my lord,
I-
100 times, my lord. If there is an
No, madam, one thing,
This-
madam,
Malcolm,
madam,
take it
one
off.
thing. Just because the senior council says something does not mean that we have got to follow it.
Lordship, in other.
No, I'm saying to the court, my lord, we expect the public prosecutor to be.
He's-
No, no, no.
Council,
This
he
is
should
it.
encourage
This
us,
is it,
Lordship.
my lord. This is
This
not,
is-
what kind of
this is-
encouragement he was asking for?
Is this a way of saying us like this, Lordship?
Yes,
Always.
I'll say, my lord, yes, my lord.
He should encourage us. He should.
This
say
is not, there's a case of encouragement. My lord. The 80 years person in the custody, the division bench is there.
He did something that-
She's making submission and he's making a prayer for taking up this matter and for praying for disposal without calling for the case, lordship LCR, local records. All it is maybe apparent on the face of the record that the judgment is illegal or irregular or whatever may be, your lordship, but for angels, your lordship will peruse the records.
Not
And your
necessary always, my
lordship,
lord.
No,
This is
opportunity
not
to
necessary, my lord.
public prosecutor
You see,
by
madam-
The opportunity has been given, my lord.
No, just a minute, just a minute.
Enough, your
just a
lordship,
No,
lordship
no.
from your lordship.
No, just a
experience,
minute,
my lord.
just a minute, madam. You see, one thing is, I just want to make it very clear to you, he's not going to influence me in any way. Okay, just because he's a senior counsel, but I have to give due respect to his submissions.
Lordship.
Okay, and one thing, please understand, Don't,
Personally,
you all are trying to give, this.
Lordship, our inconvenience, the lordship will kindly consider. One day, is it enough, your lordship, to go through the entire record, 17 witnesses and the.
We are not on merit of this case, my lord.
Are in vernacular.
We
No,
are not
no,
on the
no,
merit
no,
of the
no,
case.
madam, one thing. When the court itself has said, when the trial court has said that PP is not adducing any further evidence,
Lordship,
What
that
remains?
lordship, whatever this, I am not questioning about whatever documents is submitted on the criminal appeal. But there is no question for calling for the lower court records. If the documents submitted by any of the parties are considered to be gospel truth by this honorable court, lordship, let the records come up before this honorable court, Puno district. Bottom town nearby, my lord, later records come, entire matter may be taken up. There are judgments here, lordship, in your.
এটা বুঝিয়ে পারো।
okay, right. Ms. A. Begum is granted time till 23, there is 23/9 to file her opposition, a written objection,
Oblige.
list the matter on 25.
Lordship, judgment is of 5/6/2024.
So?
He is talking about personal liberty, we are in September, 3 months.
So it depends.
Well,
upon
the High Court, can we see the observation made by the High Court in the previous judgment? How can he sit over the judgment of the High Court. That is my only answer. Question, my lord, to the public prosecutor. Can the trial court can sit over the judgment of the division bench of the High Court, my lord? This is what is happening. Just she can answer it, my lord. I'll not pray for the, my lord. Then I'll not pray for the bail, my lord. If she can answer it, my lord, the observer, my lord, kindly see the observation, my lord. Lordship, I'm not on Supreme Court. The division, they have not challenged the order of the High Court, my lord. This court, they have not challenged the order of the High Court remanding back for taking fresh evidence. They have not challenged the prosecution, my lord.
I'm trying
Then
to make
they
a
have
submission,
agreed.
my lord.
My
The
lord.
cases wherein
No.
lordship clients
The-
and persons are involved, 80 years old, their cases should be given preference.
No, that's not
And
the only
then
question, my lord.
taken
This
up
is not
decisions
the,
of my lord.
80 years is not the only consideration, my lord. 80 years is not the only consideration. My consideration is there's a direction from this Honorable High Court by division bench to the trial court to take fresh evidence. By defying that order, the person who was acquitted earlier, he was convicted on the same evidence where the High Court has failed. Lordship, kindly see the language by the High Court. Kindly see
I've
it.
seen.
The High Court said that we could not arrive in any decision, my lord. That
We'll-
was the observation.
We'll take it up on 25th. So we decided 25th. But prima facie,
Lordship,
it appears that the appellant has got a point.
Lordship may hard it on 25th.
You see, I don't understand why you have to go into evidence because there's no evidence to go
That
into.
is why, what I am saying, my lord.
There is no
We are
evidence.
not
to
on
go into.
evidence.
Because this court had said that additional evidence should be taken. Now, no additional evidence is to be taken. So what evidence are you going to go into? I don't know.
Yes, absolutely, my lord. That is what I am saying. Why LCR is required. That is the certified copy is there. The judgment of the order, my lord. The free copy.
Yes, sir.
Then why it's a requirement, my lord? That's the, I fail to
So
understand.
that is the issue. The issue is when this court has said that additional evidence has to be taken.
Lordship, this fact, Lordship, then Lordship, as regarding 389, Lordship, then Lordship, there should be direct hearing, Lordship, no 389, then.
That's why this
Okay,
Lordship is
I will
given the
get
right-
here direct hearing. If
Then-
you want direct, we'll fix
then
it. They have to tomorrow.
I,
They withdraw it.
they let them withdraw the then LCR will become the Lordship may hard.
Then again, they will go for the LCR, my lord. That is the ploy they have taken.
Lordship, how?
That's if they are playing with the game, my lord. This is only to defy the judge.
Without
Nothing, my
LCR,
lord.
how-
When the judgment, the free copy of the judgment is there, the certified copy is also there. How they can say that they require the go through the judgment, my lord, the evidence? Why the evidence is required? When there is no evidence at all. Only they are, as Lordship is
Lordship
saying.
will have to go through the paper book, Lordship.
No.
Without
Why?
LCR, Lordship, this.
Oh, no, where's the question of LCR?
What? This is it.
Why can't I? Why can't
I
I?
leave it to your Lordship, my lord.
Madam, no,
Let them withdraw the I,
no, madam.
Why should I withdraw the IU, my lord?
Madam, let me ask you a question. Why can't I accept?
Then Lordship.
Why can't I accept? Please understand the question.
I have Lordship.
Why can't I accept the observation made by the trial court to be true?
Then, my lord, the only
No,
one.
just a minute. Why
Lordship,
can't
then
I
they-
accept why can't we accept
then
the
Lordship
trial
may
court
hard it
observation?
Friday.
No, you tell me. Yes, we'll hear it on Friday if you want. Listen,
Let
madam,
Lordship-
Friday.
let them withdraw the I, Lordship.
No,
Then
no, no.
No, my lord, that
Then
judgment will go, my lord. Definitely, my lord.
Regarding.
I will not
Lordship,
press
we'll
for the
have to
IA.
file
Just
the
a minute,
procedure.
Mr. Counsel.
We'll have to file, Lordship.
No.
There is a 318 and I will have to file objection, Lordship, as it is belongs.
You
to
can
them.
go to Supreme Court. I know you're going to rely upon that judgment. You can still go to Supreme Court, supposing we find there's nothing here. You see, I don't understand the reason why you have to go to the evidence when there is no change in the evidence.
Lordship, then
Lordship, but this is fresh appeal, this is fresh IA. So
On
under
the
provisions of.
Old wine,
File an
old wine in new bottle.
Maybe, my lord. The reappreciation, everything your lordship can always have.
No.
the
There's a
negative-
direction.
Lordship.
No,
always
that
says
direction was not being challenged. But
They
that
need to
direction
file
was
an
not being
objection.
challenged.
Okay, you just right.
On Friday, my lord, Lordship can take up and set aside the judgment itself. No need to hear the, my lord, the IA. No need to hear the, on the face of the record. Lordship can set aside the judgment of the trial court on the Friday itself.
No,
There is no need to go for the, my
no,
lord.
since we have already passed the order, I think. Wednesday.
My lord, in this case, my lord, under section 6, my lord, 15 years conviction, my lord. Special POXO, my lord. Pokrajar.
Under section 6.
6.
Yes, so you can tell me, the appeal has been filed.
Yes.
Oh, it's the first time?
First time, my lord.
Notation. Yes, my lord.
It may go, my
Respondent number?
respondent number 2,
Who is he?
father.
Father Lord.
Yes, Mr.
A.M. Ahmed.
Heard Mr. A. Mohammed, learned counsel for the appellant, who submits that the impugned judgment dated
13A.
13/8/2024, judgment and order dated 13/8/2024, passed by the Special Judge POXO, Kokrajar, in case number special 10/2022, by which the appellant has been convicted under section 6 of the POXO Act. Read with section 368 IPC should be set aside. Admit the appeal, call for the LCR. Issue notice returnable in 4 weeks. Miss A. Begum, additional PP accept notice on behalf of the state. Then the rest is the same, that other part.
And my lord, in this case, my lord,
For point number 2.
in this case, though I am signature in the Ogalatama, my name not in shown in the call list, my lord. Registry may direct that on my name in the call list.
Okay, registry to reflect the name of Mr. A. Ahmed in the call list.
A.M. Ahmed.
A. Ahmed. Acha, then you write in the, there's IA.
Yes, there is I.
That has not been listed. But there is, okay, in the IA, right? Heard Mr. A. M. Ahmed, learned counsel for the applicant who submits that the application for suspension of the sentence under section 389 IPC, CRPC should be allowed, and the petitioner and the applicant released on bail. Ms. A. Begum, additional PP is granted. How much time?
4 weeks.
4 weeks time to file written objection. List the matter after 4 weeks. Yes, so we,
Lordship, the last occasion, Lordship, we have issued notice to the IO Lordship, but we have not received Lordship, till date Lordship. So,
no,
yes,
Yes.
huh?
Lordship, one more aspect here. 2 sets of paper book is prepared, but we have received only one. So registry may be directed to.
2 sets of paper book. Why should there be 2 sets of paper book?
There are, I think, 2. It's written in the call case to paper.
No, there is, no, there's only one paper book. There's no question of 2.
Lordship, she'll have to take a fresh step, Lordship, for informant Lordship. And
Fresh
it was
step or,
1 year before she have
Or
taken. that we have-
Lordship can appoint amicus.
well, let us appoint
It is
amicus better,
also there,
right?
Lordship.
Heard Miss
So
T. Somler, counsel for the appellant, as well as Miss R. Begum, additional PP. There is no report from the OC of the concerned police station with regard to service of notice upon the respondent number 2. Till date. So as such, we are of the view that a legal aid counsel should be appointed to take up the case on behalf of the respondent number 2. Who will be appointed? We should appoint or the registry will appoint?
Registry will appoint. Registry will appoint.
Yeah, registry to appoint legal aid counsel to take up the case of the respondent number 2 and furnish a copy of the paper book to the legal aid counsel. List the matter for hearing after.
Lordship, after 4 weeks.
After 4 weeks, so that let there be a fixed date, Lordship.
You give a date.
Yes,
Lordship, a copy may be served to us also, Lordship.
mid
A
of
paper
November,
book,
Lordship,
we have
mid
not
of
received the
November.
paper.
Better know.
Yes.
List the matter on, give a date. 3rd November, huh? Wait. Paper book furnished upon Miss S. H. Bora, learned additional PP.
I'm deeply obliged.
May I please, your lordship. In this case, your lordship, I has come for consideration of bail, your lordship. It's a POCSO section 6, your lordship, conviction for 20 years, your lordship,
20 years.
20 years.
And the victim is how old?
She was, your lordship, according to the medical, your lordship, 12 to 14 years. There is no other documents, your lordship, they have abused, your
So
lordship.
age is not an issue.
Age is not an issue, your lordship. We have not raised any objection on that also, your lordship, during trial, your lordship. Only thing, your lordship, so far as the present case is concerned, your lordship, the victim was not examined.
Victim not examined.
Now, when victim was not examined, your lordship,
Victim not examined by doctor.
no, not by doctor, not in the trial, your lordship.
Asha.
Victim was not
Not examined by.
by the
okay.
trial court, your lordship. That's the, your lordship, the my foundational case, your lordship. Once, your lordship, it is not examined, your lordship, there is absent, there is no eyewitness to the incident.
Why was the victim not examined?
That has also not been explained by the learned court below, your lordship. Why that has not been, and she was not examined, your lordship. Her 164 statement was exhibited, your lordship. 164 was recorded by the magistrate, your lordship. But that 164 statement was exhibited. But
Who is for the respondent number 2? For the victim?
am I?
Yes, why? Why is the victim not examined?
My lord, that official part I cannot submit, my lord, but maybe because, my lord, in the statement, my lord, the father of the victim informed that, my lord, she is mentally now not fit, my lord. Maybe that.
Mentally not fit.
Yes.
But then that should be somewhere in the records. Is it
Yes,
reflected?
in the cross examination,
Of
but in the judgment, it's not clear.
Lordship will kindly come to page 20, para 26 of the judgment on the fitness of the guard, your lordship.
yes.
Para 26, your lordship. Also, the mental status of the victim guard that she was mentally weak is also to be taken into. At this point, it is to be noted that the term mentally weak has been used in other.
19 of the criminal. This is para 26. This is 363.
363, your lordship.
Huh?
Criminal appeal number 363.
363. Para 9, 26 different. In para 19. 19, page 26.
The pagination is not that. It is, page 19.
No, anyway, para 26.
Para 26.
No, para 26 also, huh?
Yes.
Pagination is not that.
Okay. Yes.
Para 26. Also, the mental status of the victim girl that she was mentally weak is also taken into consideration. At this point, it is to be noted that the term mentally weak has been used in Azahar, but at the same time, it cannot be said that victim girl was in a condition where it was not possible to express herself. If the evidence of the father of the victim girl PW1, the mother of victim girl PW2, PW4, PW5, Lanbalo Begum has gone through, all of them deposed that the earlier the victim girl used to attend school, but later on she stopped going. Thus, it cannot be said that victim girl was totally incapable to express herself. Even her statement under section 164 CRPC was recorded and same was exhibited as P Exhibit 5. PW9 learned judicial magistrate first class Orbitaker further deposed in her evidence in chief that at the time of recording of her statement, she did not find any inconvenience on account of any mental illness on the part of the victim girl. The statement has been proved by the learned judicial magistrate who had recorded the statement. With this finding by the last court below, your lordship, what is more there, your lordship? And in fact, your lordship, why her cross-examination was necessary, your lordship? The PW1 mother has deposed that the incident occurred at the night. And now she in her 164 statement has made a very categorical statement that it has occurred at 4 PM in the evening, your lordship. These contradictions.
So 4 PM might be dark. What, was it winter time? What time was it?
Winter, you know, in November. But your lordship, dark is there, but
Which may be granted if lordship.
Then there'll be thing. Give me the main case. Right. Where is that acceptance notice? Where? You said notice has been followed.
No, I haven't said that, your lord.
Huh?
I haven't said that report has come.
No, what did you say?
I just told that notice was issued, your lordship. That's one number. That's it, your lordship.
Okay, right in the main case. Mr. Huh? KK Das. Addition PP shall obtain instructions as to why the notice has not been served upon the respondent number 2 by the OC All Women Police Station. This is the matter. 1 week later. After 2 weeks.
They be obliged.
For 2 weeks. Yes, Mr. Das, any objection?
Is your lordship?
Any objection? The 690 days delay.
Oh, no.
No, right.
And
Miss,
similar petition, my lord, appeal.
what is your name, madam?
Dear Sultana, my lord.
Heard Mr. B.R.A. Sultana, learned counsel for the applicant, who submits that there is a delay of 690 days in preferring the appeal against the impugned judgment and order dated 8/8/2022, passed by the learned additional sessions judge cum special judge Pokso Shipsagar in Pokso case number 38/2021 under section 448/376 bracket AB IPC read with section 6 of the POCSO Act, sentencing the applicant petitioner to undergo RI for 20 years with a fine of rupees 10,000, in default RI for 3 months. Mr. KK Das, learned additional PP submits that he has no objection to the delay being controlled. Full stop. On considering the grounds for the delay and keeping in view the submission made by the learned additional PP, the delay of 690 days is condoned. Registry to register the appeal and list after a week. I is accordingly allowed and disposed of.
Yeah, may I please, your lordship? But it's an I petition against for the condonation of delay of 72 days, lordship.
Notice was issued.
Lordship, it's a matrimonial appeal, lordship. Appeal against
So?
the judgment of the.
So was notice issued?
Yes, notice was issued and it was also served upon them, lordship.
Served upon them.
Yes, lordship. As per office note dated 11/9. Service report is also due.
No, okay. We'll allow it. Heard Mr.
K Das, Your Lordship.
K. Das, learned counsel for the applicant dependent. Then you take this first order, 14,624, the second paragraph, huh? Good stuff. Then you write. Actually, before that, you write, Mr. K. Das, learned counsel for the applicant dependent. No one appears for the respondent, huh? Then this paragraph, huh? Then next after that you write. Notice was issued to the respondent on 14/6. Was issued to the respondent on 28/6/2024. In terms of the order dated 14/6/2024 passed by this. Office note dated 19/8/24 and 11/9/24 states as follows. I take it down. The above clearly shows that notice has been served upon the respondent. On considering the grounds for condoning the delay of 72 days, we find that sufficient cause for the delay has been made up. Accordingly, the registry is directed to register the appeal and list the same accordingly. List the same after a week. I is accordingly allowed and disposed of.
Obliged.
Let me go, Lordship. If the matter can be taken up post lunch, there are two I's. One is become infructuous.
Huh?
There are two I's listed in Act number 13. One I is infructuous. The other I, Your Lordship will have to adjudicate on whether the I can be allowed or not. I number 2697. At 2 o'clock, Your Lordship, you guys some.
If I may, Lordship, I appear for respondent number 3, 4, and 5 in this matter. Lordship, we have not been served a copy of the IA, Lord. 3, 4, and 5, Lord.
So we'll take it up at 2. And so I don't think any order can be issued anyway.
If notice can be issued, if Your Lordship deems.
Huh?
If Your Lordship deems that notices.
I don't know. I don't. We'll see. We'll see at 2 o'clock. At 2 o'clock.
May please your lordship, but before my learned senior starts, I seek your lordship indulgence to make a small prayer. My lord, in this IA, my lord, in this entire case, I am representing the Bhattadev University.
Here is representing
Bhattadev University and Badalu. And they are seeking relief against us. Apart from us, all others have been served copy, we have not been served copy in the IA.
So they have not been served copy. That's what.
No. I have checked the notice also. Education department, government, they have given, but Bhattadev University has done. So I pray
I'll
that
solve them, my lord, then.
Actually, one thing, this one IA is infructuous.
Yes, my lord. IA 22560 has become infructuous.
Okay, right. Mr. M.K. Chaudhary, learned senior counsel, submits that IA, the present IA has become infructuous.
There are two IAs, my lord. 2560 has become infructuous.
In view of the submission made by the applicant's counsel, the present IA is dismissed as infructuous. That is 2560. Now, with regard to the other case, IA.
My lord, I will serve him copies of the, my lord, appeal and the IA today itself. Let it come on Friday. I'll serve the copy. Let it come on Friday, my.
Why Friday?
My lord.
Why Friday?
On the, at the earliest, my lord, because there is urgency, there is a prayer.
I don't know. Your case is what? Your probation period ended in May 23.
Yes.
May 23.
But much prior to that, my lord, my services were dispensary, and that was my lord.
Your only problem is with regard to the fact that you are saying that it is stigmatic.
It is stigmatic and my lord, there are two provisions in the my lord, rules. The provision has not been my lord applied correctly.
Anyway,
That is
we'll
my
see.
case. But what happens, my lord, there was an interim order. My lord, there was an advertisement for the post that was stayed, my lord, during the life of the repetition. And then, my lord, now after the, my lord, dismissal of the repetition, my lord, a fresh advertisement has been passed, issued, my lord. And if, my lord, that recruitment is made, and eventually, my lord, if my reputation is allowed,
But that was because your termination was prior to the completion of your term.
yes, my.
And
No,
that is
term
why
means, my lord, no, my lord, it was not for a limited term. The, my lord, the lien was for a limited term. So, my lord, after the completion of lien, or maybe before that, my lord, I would have, after the completion of the provisionary period, I would have been regularized there, my lord. Otherwise. So,
regularization is a different thing altogether. You cannot, there's no right to
my
regularization
lord,
for a person.
regulation
who's
means,
on-
my lord, not in the way, my lord, we talk about regulation in other education matters, my lord. Here, there was a regular selection. Pursuant to that selection, I was appointed as the, my lord, registrar. But, my lord, I kept the lien of the Guwahati University because, my lord, there was a probation period. So after the completion of the period, my lord, there was no question of regularization as such, but my lord, I would have continued. And my lord, now, if
Anyway,
advertisement is issued, my lord, and the post is filled up by another person, my lord, a third person right will be created. It will also lead to multiplicity of proceeding. And your lordship will hear the, my lord, main readable in the meantime.
But anyway,
Day after,
let him be given a copy of the appeal.
or day
I mean, the
after,
application.
day after or Friday, my lord, whatever is convenient to your lordship.
The after or Friday, the same date.
Day after? Probably after. Day
As
after.
per your lordship's convenience.
The after and Friday is the same date.
Let it be after.
So you are saying take a toss up between the heads minus the tails or something like that.
My lord, day after, Wednesday.
Okay, right. Mr. J. Patwari, Learned Counsel
Friday.
appearing for the
I thought it was a Monday.
Bata Dev University submits that he has not been given a copy of the application. That is IA number
I number
2697 of 2020. Mr. M.K. Chaudhary, Learned Senior Counsel, submits that he will furnish a copy of the same to Mr. J. Patwari during the course of the day. Yes, anything to say?
They will not have anything to say at least.
What is their name? Mr. A. Day appears on behalf of Mr.
Guwahati University.
Appears on behalf of the Guwahati University. Lives the matter. When?
Friday, my lord.
Friday. Okay. Friday.
Obliged.
No. What is this? Mobile or what?
Mobile, exhibit of mobile.
Why this?
The Lordship was pleased to issue notice on 29/5/2024. Yes. So all are similar. There are another two repetition are there. Lordship has pleased to issue notice. Because in this case, what happened, Lordship, there is a difference between the dates. The assessment was what was passed on.
Huh? What is it? No notice was issued.
In two Lordship notices been issued on 29/5/2024.
No?
In this case, no notice was not issued. There were four review petitions.
No, here also no notice has been issued.
Yes, Lord. In 68.
68, no notice was issued.
Lordship on 29/5/24.
Acha. Okay, 29/5.
Yes, Lord.
But anyway, in this Ashish Agarwal, the matter pertain to the unamended 148 anyway.
Yes, Lordship, but the assessment here was different, Lordship. And that is squarely not applicable. On that date, mistakenly it was submitted by me that is applicable. And the notification on which the petition is relying on is also clarified. And there is a difference of dates. So that's why Lordship has pleased to issue notice.
The dates of the assessment there.
Yes, Lord.
And in Ashish Agarwal, what is the date of the assessment there?
Lordship, it is unamended.
Unamended. So
Yes.
here also it is unamended.
No, Lordship, here, Lordship, please to see. Paragraph 5 of my application.
Paragraph 5. Which IA? Which review?
Lordship, all cases are same.
Paragraph 5. Okay. Yes.
That the review petitioner beg to state that the cause of action Union of India versus Ashish Agarwal is not applicable in the instant case, as the notice was issued on 31/3/2021, within the time limit, and the assessment was also duly completed on 14/3/2022. But in the order dated so and so, passed by this honorable court in the date of notice was mentioned as 31/3/2022. The honorable court has therefore wrongly set aside the impugned notice dated 31/3/2022, as there was no such notice issued on that day. As there is no notice issued on that day, the instruction number so and so is also not applicable in this case. In other cases, Lordship, hearing, Lordship, after hearing, Lordship issued, please to issue notice in all these three cases. Two are also not listed before your Lordship.
Show me this Ashish Agarwal. Let us see.
Lordship, Lordship is 15, Lordship is please to quote some paragraphs of Ashish Agarwal. Lordship,
Yes.
today is not, the judgment is not with me. Lordship.
Yeah.
Lordship, may fix another date, I'll place all this material before. And along with two other review petition, in which also Lordship will please to issue notice.
List this matter on the prayer of Mr. Ezekiel. List the matter on Monday.
Along with two other review petitions.
Along with Swenson.
I'll provide them.
No, you was different orders.
Lordship, in another case, service has been completed by the Lordship.
Anyway, you give them the number.
Lordship,